Bien, ben, je propose que nous commencions et je vous remercie d'avoir bravé les conditions. Je ne sais pas si elles sont si terribles, mais je pense qu'elles ont été rendues d'autant plus terribles qu'à cette époque-ci de l'année, on ne s'y attend plus. Et visiblement, en tout cas, pas les autorités, puisque c'était assez compliqué pour tous ceux qui devaient arriver jusqu'ici. Et donc, on a reçu de la part d'un certain nombre d'étudiants, mais aussi de collègues, des messages disant qu'ils ne pourraient pas venir aujourd'hui, ce qu'on comprend bien. Ce qui n'empêche que pour nous qui sommes là, et pour ceux qui vont pouvoir écouter la conférence, puisqu'elle sera également enregistrée et mise en ligne, nous sommes très heureux et honorés de recevoir aujourd'hui le professeur Suzanne Haack, qui est professeur à la fois de philosophie et de droit à l'université de Miami. Alors, le professeur Haack est comme je vous l'avais déjà dit la semaine dernière, je le répète, est une des meilleures spécialistes mondiales sur le pragmatisme et notamment le pragmatisme juridique. Et son œuvre, que je ne vais certainement pas résumer ici, mais se caractérise par une grande indépendance d'esprit et liberté de pensée qui se traduit notamment dans les choix de ces thèmes à la croisée de la philosophie et du droit, et à l'opposé d'une certaine philosophie classique du droit. Et on le voit notamment et spécialement par l'attention qu'elle porte à certains problèmes qui sont au carrefour de la science ou de l'épistémologie ou de la logique d'un côté et du droit de l'autre. Et on pense tout naturellement à une des questions sur lesquelles elle a beaucoup travaillé, qui est celle de la preuve. Donc elle a publié notamment des livres comme Inquiry and Evidence, ou alors j'attire votre attention entre beaucoup d'autres livres que vous verrez, et certains d'autres livres que je ne mentionne pas vont passer entre vous, Trial and Error sur la philosophie de la science développée par la Cour suprême des États-Unis. Et donc, on remercie beaucoup Madame Haack. Comme d'habitude, ceux qui viennent de plus loin sont ceux qui arrivent, sinon le plus facilement, du moins avec le plus de détermination. Donc on la remercie d'être parmi nous et je vais lui céder la parole. Elle va donc nous parler dans une conférence qui aura lieu en anglais. Après, nous aurons une séance de questions-réponses. Il n'y a pas de problème à poser vos questions. Ne soyez pas timide. Si vous ne sentez pas de les poser en anglais, vous pouvez les poser en français. Madame Haack comprend en réalité très très bien le français, mais la conférence sera en anglais et elle portera sur les pragmatismes juridiques, une défense du pragmatisme classique, de la tradition classique, une critique de certaines vulgarisations récentes et aussi sont annoncées quelques remarques à propos de ce que Madame Haack appelle Eurojurisprudence. Merci beaucoup, je vous cède la parole. Et je fais circuler les écrans.
Okay. Merci. Il y a 30 ans, j'ai parlé assez bien français. Maintenant, j'ai oublié presque tout. Je regrette. I'm sorry. Now I begin to speak French and it turns into Spanish halfway through the sentence. So I've lived in Miami too long. Okay. All right. Some questions about Eurojurisprudence will come at the end. And you know where you are, but it was new to me. Let me start by talking about the classical tradition in pragmatism. Oh, am I between you and the slide? It's okay? It's okay. American pragmatism is a school of philosophy, the only native American school. Everything else that the Americans have taken and run with was a European import. This was an American school. It arose out of discussions between Charles Peirce and William James, both of them very young at the time, at the Metaphysical Club, as they called it, in Cambridge, Massachusetts, in the early 18th century. This was a very, by modern standards, this was a very unusual philosophy group because it included as many scientists and as many lawyers as it did philosophers. There they are, both very young. That's Peirce in his graduation photograph from Harvard, where he was not a philosophy student, but a chemistry student. And William James, who looks like every philosophy graduate student I have ever known. It was Peirce who introduced the word pragmatism at the club. But he never used it in print for decades until James already made it famous. And he figured, I guess, what's to lose? The reason was that at that time, the meaning of the word pragmatist was very unfavorable. It was very pejorative. It meant officious meddlesomeness. So a pragmatist was what we call in English a busybody, somebody who interferes in everybody else's business. Well, you don't want to call yourself one of those, do you? Okay. Peirce and James both insisted pragmatism is not a body of philosophical doctrine. In that it's, I think, unique among schools of philosophy. It's not a body of doctrine. It's rather a method of doing philosophy, which they both described as the method of the pragmatic maxim. Here are two formulations. One is Peirce's, the other is James's. Peirce's is that the meaning of hard concept is given by the experiential consequences of its applying. So that a hard concept like, well, his first example is hard. Hard is a hard concept, he says. What does it mean to say that the diamond in my ring is hard? Well, if I were to rub my diamond against the window would scratch and not the diamond. That's what it means to say that it's hard. Now let's apply this to true, real, all those hard philosophical concepts. Okay. You look for the consequences for experience to understand those concepts. James's formulation is easier, but in the end more slippery, I think. There can be no difference that makes no difference. As time went by, the differences between them, which were already apparent in those two formulations of the maxim, grew larger. I think the most important change was, as he matured, Peirce became both more strongly realist and more broadly realist. I mean in a metaphysical sense, not in a legal sense. Peirce had almost nothing to say about the law. Whereas James was from the beginning a nominalist. And his conception of pragmatism is nominalist from beginning to end. So perhaps that distinction isn't obvious to you. Some of you look puzzled. Okay, nominalism is the view that everything that there is in the world is particular. There are only particular things and events. Anything general that there is either in our minds or else in our language. That's nominalism from the Latin word nomina, which means both word and name. Okay. Realism is the denial of that there is real generality in the world. So by the time they're grown up, we have a realist pragmatist and a nominalist pragmatist. And kind of sadly, only a few years after he first used the word pragmatism to describe himself, Peirce decided it's hopeless. People are making such a mess of this idea. He invented the word pragmaticism for his own position. saying, well, that word is ugly enough to be safe from kidnappers. As if kidnappers only took good-looking babies and not rich ones. In due course, two other important thinkers would carry the banner forward. John Dewey and George Herbert Mead, who brought us classical pragmatism as we know it today. Dewey is, of course, much the better known of these. Mead was sort of half philosopher, half social psychologist, and I think wrote some of the best stuff in philosophy of mind that I've ever read. Unfortunately, when you mention him in an analytic philosophy department, they say, "Where's he?" As if he was some contemporary of ours. They've never read him. It's a great shame. What did these people have in common? They differed both in their understandings of pragmatism, and you can see a continuity, but there's no agreed-on definition. They also differed in their interests and in their intellectual strengths, so that Peirce was naturally enough interested in philosophy of science, but primarily he was a logician of a very powerful kind. James, on the other hand, was much more interested in religion than he was in science, and wrote about ethics and about aesthetics at a point at which Peirce wouldn't touch these subjects. And Dewey introduces a whole new political dimension to pragmatism, and then Mead introduces this social psychological dimension. They did have, however, enough in common that you can see there is indeed a way of doing philosophy that they share. Most importantly, for our purposes, if this were the first lecture in a class on pragmatism, I might put the emphasis slightly differently. But for our purposes, thinking of meaning in terms of consequences for experience. Thinking of concepts as growing as our knowledge grows. That's a very important point. Peirce uses initially, when he says this, the examples of electricity is one. And this one is very resonant now. Planet. Think how much our concept of a planet has grown, he says, since the first time anyone identified something as a planet. Okay. As you perhaps know, Pluto got demoted as no longer a planet a few years ago. Okay. And then 20 years later, he starts talking about a different kind of concept, not scientific. Force, marriage, law. Very interesting. These concepts also, he says, have grown. And I don't know how it is in here, but in the US, you can watch the concept of marriage growing as one state after another adopts some form either of civil union or of same-sex marriage. I have one lecture where I use this example, and every time I give it, I have to update the map about which states now allow this. Okay. Concepts grow, so you look to the future and not just the past. Okay. All the pragmatists have a strong distaste for false dichotomies. That's to say, for what Dewey called untenable dualisms, if you prefer that expression. That's to say, sharp distinctions where really, underneath all that, there's a continuity. They all adopt a kind of naturalism. That's actually a much abused word. What I mean by it is something quite modest. That's to say, they all allow the relevance of what they called the special sciences to philosophy. They don't see philosophy being overtaken by being absorbed in the special sciences, but they do see the special sciences as having a bearing on philosophy. Okay. More recently, unfortunately, pragmatism has been beset by kidnappers. I spent 10 years of my life arguing against Richard Rorty. That's him on the left. He looks so pleased with himself. It was infuriating. After 10 years, I decided that this was a waste of time. It has no effect on Rorty. It's like trying to wrestle with a sponge. And it has no effect on Rorty's friends. And it wasn't necessary with respect to the people who'd seen that this was terrible stuff. So instead, I compiled a conversation between Peirce and Rorty, using only their own words, which turned out to be absolutely the best way of showing that essentially, if you think about the intellect, you're comparing a candle to a 100-watt bulb, right? They're just not comparable. Rorty was invited to come play his own part of this when this dialogue was acted, but he said he had a previous engagement. I think it was under the sofa. On the your right is Robert Brandom, the most recent and again very successful kidnapper, who, insofar as I can make sense of him, which I have to say is quite limited, he writes the most opaque prose I have ever had the misfortune to try to read. I think he's trying to turn pragmatism into something more like analytic philosophy. And that this is a real disaster because what appeals to me about pragmatism is that it seems to me to be way ahead of analytic philosophy. So I think of this as a step backwards. Okay. All right, what about classical legal pragmatism? Well, among the lawyers at the Metaphysical Club was Oliver Wendell Holmes Jr. Henceforth, when I say Holmes, it will mean junior and not his famous physician father. He was then a young attorney, and he was a founding member of the Metaphysical Club. I've deliberately chosen a picture of him in the uniform of the Union Army. He was the only one of the original group to serve in the Civil War. He was wounded 3 times. He almost died. And I think when his legal rulings seem somewhat harsh, and some of them do seem somewhat harsh to me, I'm not sure I don't hear in the background, look, the rule of law is so important, even if you get results which are not entirely desirable now and then and now and then. Too bad. The rule of law is terribly important because think what it was like when we didn't have it. Okay. I think the Civil War marked Holmes, both intellectually and emotionally. Okay. Holmes would in due course become a famous justice of the US Supreme Court. There he is, looking quite glorious. You may notice, as he gets older, the moustache gets bigger and bigger and bigger. Very impressive. He is regarded, I think correctly, as representing the classical form of legal pragmatism, even though he never described himself as a pragmatist. Not very surprisingly, because Peirce didn't either for 20 years. And he was kind of allergic to James's doctrine of the will to believe, which he thought was nothing more or less than a philosophical defense of wishful thinking. I think there's a little more to James than he admits, but I admit, in the end, I kind of agree with him. On the other hand, he was very much impressed by Dewey, of whom he writes. You know, Dewey writes incredibly badly. You know, his writing is appalling, he says. But you know, when I read him, I think, if God were inarticulate, but was trying to communicate with us about what the cosmos is like, it would sound like Dewey. And that's very high praise. So not only did he much admire Dewey's work, but more importantly, I think, many of the key themes of the pragmatist tradition in philosophy you find in his work. Sometimes even in his rulings, not always, but sometimes. Sometimes the rulings are kind of technical. For example, he's famous for the thesis of law as prediction. The Path of the Law, which is one of his most important lectures, it's an address to the incoming law students at Boston University. So it's a new university at the time, new class of law students. This important judge is going to talk to them. And what does he say? Well, he opens by saying, you probably have all kinds of high-flown ideas about the importance of the law. I'm here to tell you, your job will be, when you're sitting in your office and a client comes in your door, to tell him what the judge would decide if the case were to go before him. That's called the prediction theory sometimes. And he says quite explicitly, the common law is not some brooding omnipresence in the sky, nor is it simply the will of the sovereign. He'd read Austin, of course. Should be understood as what the courts in the relevant jurisdiction would decide were the case to come before. And this is parallel to the pragmatic maxim. In fact, Max Fish once conjectured that Peirce might have got the maxim from Holmes rather than the other way round. I don't believe that, but they're close enough that it's not an unreasonable conjecture. I just don't think the dates quite match up. Okay. It also has the characteristic pragmatist aim of avoiding verbalism, avoiding legal formalism, if you like, and looking at the consequences. Third, Holmes is very good on the way that legal concepts grow and adapt as the world changes. Let me give you an example. US tort law grew enormously in the late 19th century. And its concepts of causation, which used to be fairly simple, got more and more complicated and ramifying. Why? Well, first of all, because in the middle of the 19th century, we went from something like 300 miles of railway track in the country to thousands and thousands of miles in a couple of decades. And there were numerous accidents at railroad crossings because people were not familiar with trains and they just stop and have a conversation in the middle and then get knocked down by the train. And you can actually watch how concepts of causation in the US legal system grow, first via the introduction of the railroads, then when there were new methods of mining and transportation. And in the 20th century, when there began to be enormous pharmaceutical companies selling drugs that were taken by millions of people, and sometimes selling versions of a drug so close that you might not be able to tell which of the many manufacturers made the drug that injured this person. And you can watch tort law adapting to this, which I think makes Holmes's point. This means, Holmes says, that the life of the law has not been logic, it has been experience. And it's very close to Peirce's ideas about the growth of meaning. Though in Holmes's case, it takes a very particular form. This extraordinary person, Christopher Columbus Langdell, what were his parents thinking when they named him Christopher Columbus Langdell? He was the first dean of Harvard Law School. And he had published a book on the law of contracts, the main thesis of which was, what we need to do is to look at all the cases on contracts. From these cases, somehow figure out what is the correct legal definition of promise. And then from that definition and logical axioms, we can derive the correct conclusion in any contracts case. And this is what judges should be doing. Find the correct definition of the key concept, use regular logic to derive the correct conclusion. Holmes very unkindly, very bravely too, he was a junior faculty member. He reviewed the dean's book, and this review contains the wonderful line that Professor Langdell is the greatest living legal theologian. Holmes thought this couldn't be more wrong. This is not what the legal system works like at all. Okay. Holmes also conceives of legal systems as constantly evolving. He says like a plant. Think of the plant that grows in your gardens that also grows in the mountains in Switzerland, only it's tiny up there, but it's recognizably the same plant. And this closely parallels the other pragmatists' sympathies with the theory of evolution, which in their day was new. These were probably the first philosophers to take the theory of evolution seriously, because they read Darwin and they understood its significance for their work. Then you also find in Holmes excuse me, a kind of gradualism, meaning, as he says in one of his rulings, I think it's about the height of boundary fences. Can you build a fence this high? Most differences, when nicely analysed, are differences of degree. Unfortunately, the law has to impose sharp lines. And that's very close to the other pragmatist stress on the concept of continuity. Then he looks to the future of the law as well as its past. Very pragmatist, this. Consider the ends which legal rules seek to accomplish, why those ends are desired, what is given up to gain them, and whether those ends are worth the price. So cost-benefit analysis of legal rules. And he's unusual in his day for stressing the relevance of the sciences to the law. For example, he writes about the criminal law. We really have no idea how effective our criminal law is, because there are certain facts we don't know about criminals. On the one hand, a criminal might be like a rattlesnake, he says, hardwired to bite if it's frightened. In that case, the best thing to do with the criminal is lock him away, throw away the key. But perhaps, he continues, perhaps the criminal is actually the product of his environment, not innately corrupt, but something's gone wrong. He doesn't, of course, use this example, but I think of the young black man in the inner city who potentially could be a successful businessman, but has no role models except the drug dealers on the street corner, who will probably become a drug dealer because that's the only way he sees to success. Of course, that's a false dichotomy, right? First of all, because maybe some criminals are like rattlesnakes and some criminals are the product of environment. And more likely, all criminals are some combination of the two. Still, it shows his willingness to look to the sciences for help in understanding the law. He's very keenly aware of the conceptual difference between law and morality. He says to those Boston law students, if you want to understand the law, look at it from the perspective of the bad man. He doesn't care what's right or what's wrong. He only cares what's legal and what isn't. And that will focus you on what matters. To you, that is. And I believe, though the interpretation of Holmes here is a controversial matter, I think that Holmes is a kind of moral fallibilist, very close to James and to Dewey on these matters. Especially perhaps close to James, because James has this conception of an ethical theory as an empirical theory in which we try to figure out what's the best way of making room for most people to get what they want. So it's like it's not exactly utilitarian because it has nothing like the utilitarian focus on pleasure or happiness. But it's got a certain similarity with that. And if you think about a legal system, if I think about a legal system, I don't know if you know this metaphor. Do you know the movie Dr. Dolittle? Okay, there's an animal in this movie called the push me, pull you. Well, that's what a legal system is like. You know, one group of people pushes to get this advantage, somebody else pulls in the other direction. And eventually, enough people get enough of what they want. That's also how James writes about morality. My own philosophy of law has a lot in common with this. That's why I call it neoclassical legal pragmatism, to describe what I call the pluralistic universe of law. That's James's phrase, pluralistic universe. Comes from James's metaphysics. It's exactly right for the law. Look, US law. There's federal law, and then there's state law, different in every single one of the states. And in Louisiana, more or less, French, so structurally different, not just different in details. And then there's administrative law and there's federal law, besides that, and special law about Indian reservations. It's already a pluralistic universe. But it's part of a bigger pluralistic universe, which includes the law of England, Canada, Australia, New Zealand, etc., which is part of a bigger universe, which includes European... Now, you see what I mean. All right. Perfect metaphor for the law. Like Holmes, I stress the constant evolution of that pluralistic universe. For example, the shifts in the meaning of key concepts. And the way that legal truths are made true by things people do. Sometimes the writers of constitutions, more often legislatures in some already existing system, and the judges who interpret what the legislatures wrote. I don't think correct legal decisions can be logically derived from legal axioms. But this is actually kind of an interesting story. When Holmes and Langdell were having this disagreement about the place of logic in the law, the only logic available was the syllogism. And they both write about this in terms of applying the syllogism. I think it's amazing that neither of them noticed that Langdell's project was hopeless for a very simple reason. The concept of a contract is relational. Right? X promises Y to do A for consideration C. That's an inherently relational concept. And the Aristotelian logic that they were both considering as what would apply won't deal with relations. That was why we needed modern logic. So it's a serious question whether modern logic, which is much more powerful than what they had available, and which was being developed even as they disputed with each other. Peirce and Frege were working away, developing modern logic, exactly when Holmes and Langdell were debating. I don't believe that you can have a legal logic in the sense that Langdell was looking for, even with the much more powerful apparatus. That's a large claim which I've argued for in a different paper. That doesn't mean that I think legal decisions are invariably arbitrary and capricious. That's not the alternative. They're not logical theorems, but it doesn't follow that they're bound to be arbitrary and capricious. Like Holmes, I want to stress the differences between law and morality and the interrelations between them. And insofar as I have a moral philosophy, I'm sorry, but when I was a student, when I was your age, any woman who went into philosophy was supposed to do ethics. And I guess I'm kind of counter-suggestible, because I said, hell no, I want to do logic. I was very disappointed when I discovered that both Dana Scott and Hilary Putnam were men. And it's only much more recently that I've dared to think about ethics. Truth to tell, I always thought ethics was a lot harder than logic. I think I still do. But I find myself much in sympathy with the sort of James Dewey empirical moral fallibilism line. And like Holmes, I see the law as sometimes, but not as he thought, always, an engine of moral progress. I think legal systems can go backwards morally as well as forwards. He didn't, of course, have the example of Nazi law to point to, but I'm sure there were examples even then. Over the last 20, 30 years, there has been, I don't know, what should I say, a plague of issues of law reviews, volumes of essays, single books about legal pragmatism. You'd think there was a renaissance. In fact, one of those symposia is actually called The Renaissance of Pragmatism. Unfortunately, this renewed interest in legal pragmatism disguises utter, unbelievable confusion about what legal pragmatism is. A disaster, an intellectual disaster of the first order. This is such confusion. Some people take the view that pragmatism just has its current ordinary meaning. And its current ordinary meaning in English is concern for expediency rather than principle. So you think of the politician with not too many scruples, for example, if I say pragmatist. That's not what philosophical pragmatism was, and it's not what Holmes's legal pragmatism was either. Or law professors in the States sort of pride themselves on being what we call a quick study, if you've heard this expression. It means, mention some new topic to me. Give me 2 weeks and I can become an expert on it. Well, yes, in some sense they work harder than most philosophy professors. But what you get is a lot of very, very superficial understandings of difficult topics. And some of the people who take this view end up with the idea, well, pragmatism is a body of doctrine, so it's Peirce's theory of truth, or it's Dewey's political philosophy, or something, which kind of misses the point of pragmatism altogether. It wasn't ever a body of doctrine. Okay. Even worse, a lot of people, for some reason, take pragmatism to be anti-theoretical. That's not a typo. The capital T is intentional, because theory in a US law school has a very, very special meaning. It means a theory of how judges should interpret the law. So you have, for example, feminist legal theory, which says always interpret the law in such a way as to be compatible with my brand of feminism. I have a colleague whom I'm avoiding in the corridors because I don't really want to discuss this with her, who recently published a paper about constitutional law, about the Establishment Clause, arguing that we should interpret the law about the establishment of religion, or law against the establishment of religion, in a way compatible with feminism. Every time I see her coming, I sort of, I don't want to discuss this. This is just too crazy for me. Anyway, that's what theory with a capital T means. It's not always feminist. There are all kinds of legal theories, but they're essentially interest group theories. The most influential proponent of this style of pragmatism is Judge Richard Posner. He was a federal judge in the Ninth Circuit, also teaches at the University of Chicago, writes books faster than I can read them. He's astonishingly prolific. He's very knowledgeable about the law. He doesn't really understand pragmatism, unfortunately. Moreover, he is also very big in the law and economics movement. I always distrust the word movement in a philosophical context. Always a bad thing, movement. And his rulings tend to stress economic factors very heavily, with considerations about justice taking a very small role. I think this is very far removed, first of all, from Holmes's comment. We have too little theory in the law rather than too much. That's not anti-theory. And while it's true he didn't offer a theory about how judges should interpret the law, that's true. He didn't say there should be no theory. He just didn't offer one. It misrepresents what I think are his largely implicit views about interpretation. Since as I read him, he certainly mentions economics. He even writes the black letter law. In law, the black letter man is the man of the present. That means the man who knows the statute books is the man of the present. But the master of economics is the man of the future. But this is just a way of referring to the social sciences generally, and he immediately goes on to give his example from criminology. He also sees value in the way that common law grows in part. I think this is very important. Not out of some imposition of values from above, presumably from that omnipresence in the sky, and not simply by each judge doing his or her own thing, but by a whole ongoing community of judges, all of whom have views about what's more important, what's less important, what policy goals we should be aiming to achieve, and so on. All of whom are fallible, but who need to coordinate their rulings with other people's rulings, because we put a lot of stress on precedent, and sees that a lot of people who are fallible, each of whom is fallible in a different way, may actually do better than any individual could do by himself. I think there's something very important here about the community of judges. And I think he would feel just as uncomfortable as I do. I feel very uncomfortable. Either with the idea of appeal to the decision that a judicial Hercules would make, which is what we get from Ronald Dworkin. And that Hercules seems to me to bear very disturbing resemblance to, well, Ronald Dworkin. As if, he's imposing his moral intuitions on everything. And on the other hand, I don't care for the idea that each judge can do exactly as he wishes with no checks, which would be the Posner alternative. And legal pragmatism is exactly in between. Anyone who knows me knows that the truth, as so often, lies somewhere in between is kind of a motto of mine. So I should probably tell you a joke against myself, of which I am always reminding myself. It's about a student writing an introduction to philosophy examination. It can't be true, it's too good. But he's supposed to have written, there's always a question about the existence of God. On every introduction to philosophy exam, there will be a question about the existence of God. And one student is supposed to have written in answer to this question. Some philosophers think that God exists, and some philosophers think that God does not exist. But the truth, as so often, lies somewhere in between. So I have to remind myself of this. The truth doesn't always lie somewhere in between. Okay. All right, now some questions about Eurojurisprudence. I'm hoping for more answers from you. I don't know a lot about this. I'm just feeling my way. Okay. First question that comes to mind is that Holmes is talking specifically about the common law. That's the title of his 1880 book, The Common Law. And it's a question, how far do his ideas also apply to civil law systems? I think that contrast is often overdrawn. That's the first thing. And I think the terms adversarial versus inquisitorial are in some ways unhelpful. Inquisitorial certainly suggests to me what I'm quite sure is false, that Dutch and Belgian judges are constantly pulling out suspects' fingernails to get the truth. And adversarial suggests that American attorneys are sort of trying to knock each other off their horses. None of this is true. That's not to deny there are very significant differences. Specifically, the stress on precedent in common law, which is clearly one of the mechanisms by which our law evolves. Okay, you can watch. I wonder, can you manage a pun in English? It's inherently untranslatable. But story is, imagine soldiers passing a message down the line, before there are telephones or radios or anything like that. And the first man says to the second man, "Send reinforcements, we're going to advance." Okay, he goes all the way down the line. And the second to last man says to the last man in line, "Send 3 and 4 pence," that's a small sum of money in the old British currency, "we're going to a dance." Send reinforcements, we're going to. Send 3 and 4 pence, we're going to a dance. Well, you can watch the law changing like that as it goes from one court to another, to another, to another. And there is also, of course, a very distinctive division of labour in our system between judges and juries. So, first question that I want to ask is, well, do civil law systems also evolve? I want to say, surely they do. Perhaps there's more artificial selection relative to the natural selection in a common law system. Perhaps more of it's deliberate, like breeding pigeons or racehorses, as opposed to natural selection in the theory of evolution. But still, it seems to me that there is and there must be evolution in legal systems. I've actually witnessed some, but not so much in Europe as in Latin America, where I've done quite a lot of talking to legal audiences recently. For example, in 1993, in Daubert versus Merrill Dow Pharmaceuticals, in the US, cases are called, civil cases are called by the name of the plaintiff. So the plaintiffs were the Daubert family, suing a drug company for an alleged injury to their son. In 1993, the US Supreme Court, for the first time in its entire history, set a standard for the admissibility of scientific testimony, when, that is to say, a jury may be allowed to hear testimony, scientific testimony. In 2004, the criminal code in Colombia adopted something that looks, whoa, this is Daubert. They've imported it. Even though this is a civil law system, there's something that looks remarkably like the Daubert idea there. And in 2007, the Mexican Supreme Court, I find, adopting something that looks remarkably like Daubert. In this case, on a ruling on DNA evidence in paternity suits. So I can watch this idea. Here's my thought about it. Every legal system in any technologically advanced society is bound to get in difficulty with scientific testimony, because there are bound to be problems about competing testimony and how to decide between them and what. And as it happens, the US was one of the earliest places to come up with rules to handle this. And so when the Colombians find themselves in trouble over fingerprints or DNA or something, and the Mexican Supreme Court finds itself trying to say what kind of DNA evidence may be heard and when, they look to somewhere that's already made the adaptation and adopt it. Not to mention, you can see evolution of legal systems from one end of the other to the common law, civil law spectrum. For example, in 1947, what was then India was made independent of Britain, and at the same time was divided from Pakistan. So independence and partition in 1947. At that time, both the Indian and the Pakistani legal systems were essentially English. Right. Apart from odd details, they were essentially English common law systems. By now, so I'm told, I can't read Hindi or Urdu, so I have to rely on what I'm told. But what I'm told is, if you look now, Indian law looks like a civil law system, because it's been more and more and more and more codified. While Pakistani law is still recognizably a common law system, still recognizably English, but now there's an overlay of Islamist law on top of it. There's also the question whether in a more codified system, Langdell's conception of law as like a system of axioms is any more plausible. Perhaps it is. Couldn't you derive the decision from the code? That's the question that comes to my mind. It's certainly true that logic and the law, legal logic, seems a lot more popular in Europe and in Latin America than it is in the US. Now, that's partly for an irrelevant reason, that US law schools are professional schools. We're training attorneys. We're not supposed to be academic thinkers about the law. Okay. I'm a luxury. The guy who teaches contracts is the necessity. The guy who teaches criminal law, civil procedure, they're the necessities. I'm a luxury. That's not the only reason, I guess. Certainly a lot of it about in Europe. I keep getting invited to conferences. What am I going to say? I don't think logic has much to do with the law. I have to say, there have been many, many attempts to articulate this legal logic. I remain skeptical, I have to say. Not because I dislike logic, I like logic, but because, first of all, I'm unconvinced by the extant efforts insofar as we can't read them all, there are too many, there's a new one every week. But I'm not convinced by those that I've read. But also I think I have an underlying feeling that every legal system will need flexible concepts, because the world will change. Technology will change, society will change, values will change, and you need the law to adapt. And finally, now I'm on very thin ice, but you will correct me if I'm completely confused. I think there's a class of cases that I run across in my legal work where I think, logic's not going to help me, but argumentation theory might be illuminating. So let me give you two examples, just two. First, where much of the argument that's presented looks to me to be misdirection. Like a magician. He's going to saw the lady in half. Are you familiar with this? Okay. Well, he is, of course, not going to saw a woman in half. He's going to get your attention over here while something else happens instead of him sawing the lady in half. That's called misdirection. Okay. Well, Daubert went back from the Supreme Court, which set a new standard for the admissibility of scientific testimony, but didn't decide whether or not the Daubert get compensated. It went back to the Ninth Circuit, where Judge Kaczynski wrote the ruling about the new approach to scientific testimony. It's a remarkable ruling. Because I teach a class on this stuff, I have to read it every year. And every year I get angrier with Judge Kaczynski. Why? Well, because he begins by saying, look, it's a whole new world. Last week, federal judges didn't have to know anything about science. It was not our job to determine whether or not scientific evidence was reliable. Now, my God, we've got experts saying P and contrary experts saying not P, and I, the judge, have to decide which of them is more reliable. How am I supposed to do that? Okay, so first of all, I've got this huge new scientific job. I think he's actually kind of pleased. All right, well, if I've got to do it, I've got to do it. And then he talks at some length about how litigation-driven science is inherently inferior. If the science was conducted purely for purposes of litigation, then it's likely to be less good than if it was independently conducted in a university. And you think, when it comes to the question, are the Daubert's experts admissible, he will use this new test. Right? Is it litigation-driven? Yes, of course it is. No. He finds completely different grounds for excluding it. Nothing to do with anything that happens in the first 85% of the ruling. Right? Oh, these guys are irrelevant, and this guy, though he's relevant, doesn't have a methodology, so he can't have a reliable methodology. End of story. So there's no science going into this ruling, nor is there even an application of this idea of the litigation-driven. So the only way to understand what's going on is he's misdirecting your attention, right, while deciding the case on grounds which have nothing to do with the rhetoric. It's very interesting. I'd like to take that apart, and I think argumentation theory might help me. I don't know. And here's another ruling, another kind of ruling, plurality rulings. My favorite example here is Allegheny versus the ACLU. Allegheny is a county in Pennsylvania. The ACLU is the American Civil Liberties Union, which brings a lot of cases about freedom of speech, for example. It's a case involving the Establishment Clause of the US Constitution, which says Congress shall make no law respecting the establishment of religion. Okay, people have been trying to interpret this since 1879. By the time of Allegheny, this clause was interpreted as meaning there should be no government endorsement either of one religion over another or of religion over non-religion. That was the current interpretation at the time. What was the case about? It was about two Christmas displays. These are not the actual displays, but just illustrative. The first was a nativity scene on the courtroom steps. with a banner over it which read Gloria in Excelsis Deo. The other was an enormous Christmas tree and a pretty big menorah outside the town hall with a little plaque which said the city of Pittsburgh believes in pluralism. Okay. Question: is either of these displays constitutional? And if so, which one? Okay. Under that clause. The lower court said they're both constitutional. Fine, both of them are fine. Leave them there. The ACLU loses. They appealed. The appeals court said neither of them is constitutional. Have to come down immediately. The county of Allegheny appealed, and the case went to the Supreme Court. The Supreme Court decided the nativity scene on the courthouse steps is unconstitutional, but the Christmas tree and the menorah are constitutional. This is already fun, isn't it? And legal ping pong, this is. The Supreme Court ruling is 5-4. There are 9 justices, 5-4. And it's by a plurality, not a majority. That's to say, there aren't 5 people who agree on this compound proposition, but there are 5 who agree on one conjunct and 5 who agree on the other. Okay. And no 2 of them agree about why this one's unconstitutional and that one's constitutional. So we get 9 separate opinions leading to this plurality decision. Well, this is enough to make a logician completely crazy. And if it were logic, it would be catastrophic. But I think if I look closely at it, you can learn a lot by seeing what's really going on. They're all admitting the relevance of a whole raft of policy considerations. But they give different weights to different considerations. You see what I mean? And if you were to analyze each of the 9 arguments, I think what you would find is there's an agreed set of the relevant concerns, but there are disagreements about which one to give priority. And as a result, you get 9 different opinions and a plurality ruling, which actually to me makes a certain kind of sense. I mean, think of the banner. That's a religious, Gloria in Excelsis Deo, that's a religious sentiment. Think of the little plaque by the Christmas tree. We believe in pluralism. That's not. And so you get something reasonable out of this, but you get it out of this mesh of policy considerations giving different weights. Okay. And I'm hoping you'll tell me whether I'm right in thinking that while logic wouldn't be much help with this, argumentation theory might be. And that's enough wool to untangle in one afternoon. So